Then we'll move on to our regular agenda. Item 2023-071, conditional use permit for HWMC Farming, Inc. This is an item that was continued from our April 25th agenda. And Madeline, you're up.
I am up. Give me just a second to share. It's on. Sorry. I will speak up. Okay. All right, so good morning, Madeline Flandreau. This is project number 2023-071, which is a conditional use permit for HWMC Farming, Inc. This item was continued from the hearing date, to this hearing date, per the request of the applicant during the commission hearing on April 25th, as they were trying to reach a settlement with the adjacent landowner. They have since settled, and the applicant wishes to continue the processing of this application. There have been some changes since the staff report was drafted, but I am presenting the original project and will update you. So the applicant is requesting approval of a conditional use permit to continue to operate a cannabis cultivation site after losing their lease of the adjacent parcels, which had allowed them to establish the operation without the need of a use permit per Calaveras County Code Section 1795-050D2. After this occurred, the applicant had less than 20 acres available for cultivation, so a conditional use permit is required before they could alter their existing cannabis cultivation permit with the county's Division of Cannabis Control, which I'll be referring to as the DCC. So the subject site is one legal parcel that is 15.27 acres in size with two APNs, 020-028-081 and 020-029-188, and is located here at 1770 Railroad Flat Road in Railroad Flat. The parcel is zoned RA, so residential agriculture, and is developed with a single-family residence. The cultivation premises, which includes 3 separately fenced areas totaling 43,560 square feet, which is 1 acre of canopy, and a processing structure. The applicant's cultivation permit was approved in August of 2020 without a CUP because at the time of the application, the applicant leased 2 adjacent parcels owned by Colin Kelly, which are these, yes, those 2 parcels there, which brought them up to the 20-acre minimum for compliance with subsection D2. On November 2nd, 2023, Ms. Kelly notified the DCC that the lease had expired back in May of 2023 and that she was revoking her permission for the applicant to use her parcels. As you can see in the aerial image here, the cultivation premises are located on the subject parcel. No cultivation was occurring on the leased parcels. This aerial image is a couple of years old. It was simply acreage that they needed in order to meet the 20-acre minimum. So I wanted to clarify in subsection D2, it says 2 things that are relevant here. At the top of this table in the code, it states the applicant, if applying for an outdoor or mixed light cultivation permit, owns a parcel or contiguous parcels or leases all or part of a parcel on which they apply to cultivate, must conform to the following requirements. And then it has this table that states that RA zone parcels that are 20 acres or more, which is the third line down, just need to apply for the ministerial cultivation permit. And parcels that are zoned RA that are 10 to 19.99 acres in size requires a CUP and a cultivation permit. So on November 6th, the DCC sent the applicant a notice of violation, stating that the withdrawal of consent was received from Ms. Kelly, and that because the applicant's acreage now totaled less than 20 acres, they were now in violation of subsections D2 and also subsection D4, which requires that the applicant have and maintain notarized landowner consent to engage in commercial cannabis cultivation activities on the parcel. The notice of violation gave the applicant 30 days to complete one of three options. First, to apply for a CUP for the 15-acre parcel. The second, to enter into a lease for another contiguous parcel to meet the required 20 acres, or withdraw the cultivation permit, remediate the site, and reapply on a new parcel. The Planning Department received this CUP application on December 6th, 2023, within the time period that was set by the DCC. And the application was circulated for comments for 30 days, during which no agencies provided comments. However, a comment letter was received in opposition to the project from Mr. Travis Owens with Murphy's Law, who is representing Ms. Kelly. The staff report goes into a lot of detail about the opposition to the project. However, all of those issues have now been resolved between the applicant and Ms. Kelly, and they have entered into a settlement agreement. In April, Mr. Owens notified the DCC that Ms. Kelly was actually reinstating landowner consent to lease these same parcels. So the applicant's cultivation permit is now again in good standing with the DCC. But the applicant has asked to continue the processing of the CUP as a backup, just in case something falls through with the lease again. And you all have a copy, I believe, of this letter that we just received yesterday from Mr. Owens with Murphy's Law, which states that Ms. Kelly has withdrawn her opposition to the CUP, and it also confirms that an agreement is in place. And that the applicant is in process, it has purchased these adjacent parcels on the east side from Ms. Kelly, which brings their acreage now up to the 20-acre minimum. But the deed wasn't recorded before this hearing, so we're also just moving forward with the processing of the CUP just in case. So this project was processed consistent with the requirements of the CEQA guidelines, section 15168, as the proposed conditional use permit is a later activity within the scope of the programmatic environmental impact report and the addendums certified by the board to approve the cannabis regulatory program. While not required, the potential impacts of the proposed project were analyzed using the Appendix G checklist to determine if there were any new significant impacts or new information from this project, which are outside of the scope of the program EIR, but no impacts related to the proposed cannabis cultivation were identified in the initial study that you have in the attachments there of your packet that had not already been addressed in the EIR. So in conclusion, the approval of a conditional use permit for the purpose of growing cannabis doesn't guarantee that the cannabis cultivation permit will be reapproved after the applicant alters their site plan and application with the DCC. The permit application is vetted by the county to ensure eligibility under the cannabis regulatory program, and any resulting permitted cultivation premises will be subject to all the requirements for both Chapter 1795 of the County Code and the permittee's state-issued commercial cannabis license. And Mr. Zach Javon is here on behalf of the applicant if you have any more questions regarding the settlement. And that is the end of my presentation. Do you want me to leave this up?
Yes,
okay.
please. Does anybody have any questions for Madeline before we give that applicant a chance to speak?
Yes, just to clarify, we are proceeding today as if there has been no agreement.
Correct.
No settlement. The controversy still exists, and we're trying to make sense out of that under those circumstances. Is that right?
It's,
Well,
no,
not,
we're proceeding with the idea that he doesn't have sufficient land, but we
Well-
have a letter saying
Right.
that,
No, I
Yeah.
understand that, but I mean that we are, yes. Then what we are acting upon today are the conditions that existed in April. I mean, that's the source, the basis for our action today.
correct,
That those conditions still exist,
correct.
with everybody hoping that this settlement works out and everything's fine.
Yes.
I have one question on, as to what's on the screen up there. Right, what are the cultivation areas? It looks like some's green, some's gray, but
Wish I had a pointer.
I can ask that of the applicant.
I don't know. Sorry, we used to. So there are 3 fenced cultivation areas, 1, 2, 3, and then this is a processing structure.
Okay.
And then there's a residential.
If you could leave that up on the screen while the applicant's talking, having that problem.
Any other questions for Madeline? Nope. Okay, would the applicant like to speak? Or the applicant's representative?
I guess I do have one quick question. So, in the past, have we ever allowed somebody that had less than 20 acres? We got.
Yes, with the CUP.
With the CUP, okay. So we have in the past, there's precedence.
This,
Yes.
The ordinance actually says that if you have between, 10 and 20, and you're in this zone, then you can grow only if you have a CUP. Yeah. And that's in 1795.
And we have approved one of those in the past?
Oh, yeah.
Okay.
Yeah, and more than one, I believe.
a CUP? This is our first CUP.
Were the others AUPs?
We've done ZAs for cannabis.
Oh, I could have sworn we had,
No, this
Okay.
is our first CUP.
I stand corrected.
Well, members of the commission, Zach Tubon, the board on behalf of HWMC Farming and the Bakery. Take the opportunity for thank you to Val and all staff or Karen and staff for, as well as the recommendation of approval that was in place even in April prior to the withdrawal of the opponent's opposition. And I would just state, Commissioner Laddish, that that is a fundamental difference between from where we were at in April to now. The former opponent, now supporters council, is here in the audience to verify that a settlement is in fact in place, and the deeds to the parcels that are being purchased as a subject of that settlement will be recorded probably early next week. We have the original documents in my office, and they just need to make their way to the recorder's office, fully signed and notarized. But as to the subject of the CUP hearing, I think it's important to note a few things. Number one, there has never been a single code violation on this property. We're currently up to speed with the county on all of our tax obligations, as well as you can see, based on the physical layout of the cultivation site, the physical infrastructure exists wholly on the parcel ending in 188. Now, we were formerly leasing Miss Kelly's parcel ending in 086 simply for the purpose of comprising 20 acres on paper. And that was the subject of the lease. We've never occupied really any physical presence on her property as it relates to the operation of the business. So I think it's very important to note that we have demonstrated the ability to operate independently on that single parcel, or the 2 parcels, the main block in the middle and then the parcel just fronting railroad, flat road. We've been able to operate only within those parcels as far as the physical infrastructure is concerned without any incident or any issue whatsoever. Also very happy that we've been able to confer with Ms. Kelly and her counsel to resolve the prior issues in controversy, and to have their support today is important not only for the approval of this conditional use permit, should it be the will of the commission, but also for the purpose of the mutual beneficial enjoyment of each of these parties, Ms. Kelly of her residence and her property, and Mr. Macri for the continuing operation of his business, which, as Mr. Owens noted, has served to benefit both to Ms. Kelly as well as to the county. And so I'm here today asking that you adopt staff's recommendation of approval in light of these circumstances, and I'm happy to answer any questions you may have.
Well, I'm wondering why we don't, why you're not asking for a continuance, a further continuance of this until everything is resolved, and then you could withdraw your application, because if we do this on the basis of what was presented to us in April, why, I think you're going to have real setback problems. And if we well, there's, at least the way I'm reading this, there's cultivation almost to the property line of.
Can't believe the property line shown on here, but that was going to be one of my questions also.
And
So
it
maybe you
just-
can ask it,
Well-
ask if he knows if he's 75 feet from the property line.
Certainly, and if you look at the highlighted parcel, the green highlighted parcel, those two parcels ending in 189 and 083, Mr. McCree is purchasing those parcels.
No, I understand
That's
that.
not the
And that's
question.
great, but I'm looking at it the way I understand it, you're continuing with this application because something could go awry. Is that right?
We would like to have the CUP granted because of the fact that we have the ability to operate wholly on parcel ending in 188. The 75-foot setback, if you look at the garden area closest to the green highlighted parcel line, that can easily be adjusted. If you take a look at the empty space to the left-hand side, looking at it as it exists right now, between all of the, kind of to the left and down from all of those garden areas, we can expand and comprise a full acre of canopy within that space and adjust our garden area accordingly.
I think if I could address that issue, one is the property lines shown on our GIS system are notoriously inaccurate. So to rely on that visual image there is, you can't tell. The permit that was issued in 2020 would have verified existing setback requirements. Otherwise, they could not have issued the permit.
But that wouldn't have been applicable because they were leasing.
No, they were not leasing that property, they were leasing the property on the other side.
Oh, I see.
So that was
Okay,
not
so-
a part
so
of the
75
original
feet
lease.
was there.
So
Okay.
they already meet that setback requirement.
So I actually have a question related to this, the same issue, which I think I'm probably getting to the same stuff as Tim, which is, so yes, you would have the ability to move it, and that requirement would come as part of the modification to your cannabis cultivation permit. That's not going to have any bearing on us today, really. However, I have a concern that in continuing with this conditional use permit, that permit runs with the property, and any conditions we impose on you today, you will have to comply with even after you purchase that property, unless you were to let go of the conditional use permit and modify your cultivation permit yet again for the 20 acres, would be my understanding. So I was wondering if Peter or Madeline could confirm that.
The only conditions we have are compliance with Chapter 1795.
But I was
But
gonna
we
add a
could
couple of
impose
conditions.
other conditions.
That's true.
Yes,
Understood.
And you don't know what those are
in
yet.
that regard, well, I mean, don't need to be mysterious about it. I was, given that, back in April, I was going to ask the condition, a couple of conditions to be added. Applicant shall obtain a survey of property lines of the subject parcels owned by the applicant by a professionally licensed surveyor, because there were arguments at that time as to where the property lines were, et cetera. And this one apparently is already satisfied, subject to possible additional conditions imposed by the Division of Cannabis Control. Applicant shall make necessary adjustments in order to comply at the least with applicable setback rules.
And I'm happy to report, Commissioner Laddish, that actually both of those conditions are in fact satisfied. As part of the settlement that we reached, Mr. McCree and HWMC did pay for a professional survey to be conducted. The surveyor was hired by Ms. Kelly herself, and so that survey has been completed.
What a great idea.
Great minds, as they say.
So you aren't, if we added those as conditions to the conditional use permit, it would not bother you.
Those
Not-
were
not
already
released.
conditions of the cannabis control permit.
Well,
I recall that being part of the requirements
they-
there was to hire a professional surveyor and in any event of a question.
anyhow, so that was the reason why I was suggesting maybe you would want a continuance of this in case those conditions were viewed as onerous and unnecessary once the settlement is fully done. But if those conditions don't bother you, why, have no problem with
Not at all.
imposing them.
Not at all. We're happy to abide by those conditions as stated by council and Ms. Flandreau. We are subject to 1795 regardless of the CUP, and we did in fact get a survey to confirm property lines.
I think you'll want to listen to the discussion of all the commissioners, because I believe there may be other conditions that will be proposed and may or may not make it into the resolution.
Understood.
So that's all I'm suggesting, is that you're taking the chance of having the original property encumbered by conditions that you would prefer not to have.
So long as we continue or exercise our right to the entitlement to operate under the CUP.
And I'm sorry, state that again?
So long as we continue to exercise our cultivation rights under the CUP entitlement as opposed to a ministerial permit, I understand that could be an issue. I'm hoping that in the discretion of the commission that, you take into consideration all these factors that are present today in reaching your decision.
Well, I don't see how we can take in all the additional factors. If it's settled, there's no problem. If you acquire these parcels, which you have acquired but hasn't recorded, as I understand, then there is no problem. But we're looking at this as if there is still an existing problem, or at least the potential problem. That's the reason I understand that the applicant is continuing the application for a conditional use permit. We can't look at this as if everything's been solved.
I understand your perspective.
I think that they're continuing forward because they would retain the option to sell that property off and still be able to cultivate on their remaining property with the CUP if they had it. It would maintain some flexibility for them in the future.
That's certainly part of the consideration.
What's up?
Okay. Is there anything else you'd like to say?
No, I appreciate the time.
You'll have it.
Does that structure below the cannabis grow, is that Miss Kelly's house?
Below the L-shaped parcel,
Right at the crook of the L, there's a house there.
that's Mr. McCree's parcel.
What's that?
That's Mr. McCree's residence. That's a residence on,
The one at the bottom with the little blue, where it looks like a swimming pool almost to me? In the green.
yeah, I believe that's
Yes.
Miss Kelly. Is that Miss Kelly's? Yeah, Miss Kelly.
That's right.
Mr. McCree's is further up within 188.
Yeah, so that's where Miss Kelly lives.
Correct,
And she lives right there, and she's happy with what you guys have agreed with.
correct.
Okay.
I have a question, but I'm not sure who's going to be able to answer it. Reviewing the material, there was a temporary restraining order obtained, and I'm sure that perhaps you might be able to answer that better. And let's say perhaps it was resolved, and of course now you guys have come to an amicable agreement to proceed. I'm still concerned about the danger to the, I imagine some children in Miss Kelly's residence, and there's a vicious dog that seems to run about and get away and do awful things. And that's not listed in any of the information we're addressing here. It's not in the environmental impact report. It's probably not supposed to be. But what about that? Because I'm concerned about the children's safety. I know pit bulls are, designed to be aggressive, and that situation combined with children just kind of rubs me the wrong way. Please enlighten me, either one of you.
Understood. I'll state my piece on that, and Mr. Owens can elaborate. One, a dismissal of that restraining order was filed just this morning as part of the settlement, and as part of this settlement, one of the issues that preceded the CUP application was dogs from either owner crossing property lines. It was prior to the matters in controversy coming to a head. There was a friendly relationship between Ms. Kelly and Mr. McCree. The dogs kind of shared the land and ran around and played. But to your point,
Excuse
as
me,
part of
dogs
this,
cannot sign on the dotted line.
understood. As, to answer your question, certain agreements have been put in place to ensure that dogs are kept completely within that structure, or that they are allowed outside accompanied by another person on a leash. No ifs, ands, or buts about it. And that was also, prior to its dismissal, the subject of the order.
I just also want to point out for the commission that there's a separate ordinance, Title VI of the county code, which requires, it's not even discretionary, requires if the animal services gets reports of animal bites on other animals or on humans, there's measures that they have to take and take before a hearing officer or court. So that animal, I know it was raised in a very florid way in your packet, but those issues are really not resolved as land uses. They're resolved through another enforcement body and county code.
I mean, and I do
Yeah.
understand that it is not a land use issue, but that doesn't mean that we need to not discuss it. Well, I mean,
There's potentially a land use condition that could help prevent a future issue.
Certainly, we don't want to see harm to come to anyone as a result of the way that we're operating our business or the animals that are maintained on that. Certainly not any child. I would want to state just for the record that there was never any harm to any child from our animals, from our operation. There was a perceived threat by virtue of the presence of those animals. We've addressed that perceived threat to the satisfaction of Ms. Kelly, her counsel, and all the parties that were concerned here. So that's where we sit today, but I understand the concern. We share that concern, and it has been addressed adequately as far as the parties involved.
I just want to say I commend the parties on reaching this agreement. And I mean, I imagine it wasn't always very easy, but it sounds as if you've done what people ought to do, and that is get together and solve the problem. So I commend everybody involved.
Thank you. And I commend Mr. Owens as the counterpart to this debate.
Any further questions? Okay,
Thank you.
thank you. Is there any member of the public who would like to speak to this item? Nope. Okay. Anybody online, Annette? No.
Shortly, so soon.
Doesn't hurt. Me, sure.
Yeah, let's go ahead and leave it up. Okay, then we will close the public comment portion of this hearing, bring it back to the commission for discussion.
I'm going to distribute my proponent conditions. Lots of fiestas. This is effectively a gig. Lucky me. All right.
Yeah.
So, ours to go to ISG. I'll use it to.
Sure.
So,
Okay.
crack off.
Okay. Anybody have any comments, ideas, thoughts to share, questions for Madeline?
I am definitely going to have some comments, but we'll let Tim go first. He has more, I'm sure.
No, I don't.
Okay. So
Took care of things.
here's where I'm at with this. What we do today is going to basically set a precedence for a smaller than 20-acre parcel. And for me, I know this is rural agriculture, but this is a little bit different because it affects all your neighbors. If you're growing corn, that's not going to affect your neighbors. If you're growing hay, it's not going to affect your neighbors. I think 20 acres is too small myself, but it is what it is. But when we're going to allow this person to shrink the size of their parcel and still do cannabis, I think it sets a precedence throughout the county that we could see that happen in the future, and it definitely affects the neighbors. Now, nobody's here complaining right now because they've made an agreement, but in the future, there could be a lot of people that complain about it, and it is a nuisance smell, I believe, and it's different than, say, chickens, because it's not a controlled, chickens aren't a controlled substance. Marijuana is a controlled substance. So the odor that you get from a chicken, I see it differently than the odor you get from a cannabis grow. And I think that it could present a problem to us down the road, and we're going to set the precedent right now if this is accepted. And for me, I don't believe that it should smaller than 20 acres, even though you can get a CUP. That's just my belief on the subject, and I think I'm being objective and not subjective in this.
So given that they're entitled to us to consider it and then to condition it appropriately, are there conditions that would make you more comfortable with the situation?
I don't know how you could possibly,
At greater distances to property
well,
lines?
at the very least, yeah, at the very least. Yeah,
Right, you can think about that.
yeah. But we definitely are setting a precedence here today, so I think it needs to be considered.
So I think in passing the ordinance, the board has told us, we want you to consider letting, the board decided that these smaller parcels can have grows on them, and it depends on the site-specific conditions. So if there's something unique about the individual site that requires additional controls on it or requires denial, that it would, instead of, I don't know that the board, that we really have the authority to second guess the board on the ordinance, but certainly to the extent that nuisance potential has shown up in a land use way on this particular parcel, I think what we were supposed to do is look to see whether there's additional conditions or whether there's something unique topographically or what have you about this parcel that makes it impossible to grant the CUP. In terms of just legislative, how we go about interpreting ordinance.
Look how she said that so much more comprehensively than I did. You have any comments or thoughts?
Yeah, I think Tim hit it when he said they should have just, kick this down the road until it was solved between the parties. If it's going to get solved between the parties, well, then that's fine. I don't think we need to do a CUP, thank you, for something that's going to solve itself.
In 2 weeks.
Precedents, yeah. So I'm inclined to say, I changed my mind while I was listening to it. So I'm going to probably be a no.
Well, I think particularly, given the concern about the smells, et cetera, that we may well be leaning toward increased setback requirements, which I would think would complicate things for the applicant.
That's why I'm all like,
I think maybe a continuance is a good thing, even though you've had no objections to the conditions that I suggested. There may be additional conditions coming in that are just going to complicate the life of the applicant unnecessarily if indeed this whole thing gets settled.
So you're suggesting a continuance until?
2 weeks.
I think that.
I just also wanted to comment, so when, and there is actually some sort of case law on this, but if somebody applies for the CUP, even if they don't need to, when they've paid the money and applied and they have a right to apply for it, the commission does have to hear it out and provide an answer. I don't know that that a court would support. We just don't think you need one
so, yeah.
as a reason for denial.
It would have to be their choice to
They could choose to
So, okay,
rescind their request,
Which is
or,
why I was
yeah.
trying to give them a heads up of the implications of continuing down this route. Hector, do you have other thoughts or?
Well, mine is kind of consistent here, and that is, what would a delay or continuance in order for this to be concluded entirely? What effect would that have on the overall process?
So if it were continued and the applicant still desired to obtain the conditional use permit on this parcel alone, it would make no difference, other than the fact that he would have another option should the applicant decide to discontinue the lease on the other property. He could rely on the two parcels combined that he's purchasing to meet the 20-acre requirement. However, if he decided for one reason or another to focus just on the, 16-acre parcel, 15-acre parcel, that is currently where the operation is, and the commission granted the conditional use permit, then he would have the right to just solely focus on that and could dispose of that other property should he so choose. So continuance, if it's still the desire of the applicant to have a permit that would allow him to grow on the 15-acre parcel, would not change anything today, other than the fact that we would know for certain that the property had been recorded. That's probably unlikely to change, because it's going to be recorded, we'll have that option to utilize both parcels and get a cannabis cultivation permit from DCC without going through a use permit.
Just modifying their current.
Would modify the current application to change the parcel
DCC.
numbers
Yeah.
through DCC.
Right. And we wouldn't be involved, but it's up to them. So they have
So the
made an
current,
application.
the current grow is two parcels, even though it only looks like one, I guess?
No,
Well,
It's two APNs.
There's two APNs, there's the line that runs.
Is the book go through it or something?
There's, some odd reason why there's two
The book
APNs for
goes
one
through it,
parcel.
okay.
Yeah.
So, but if we allow it the way it is, they could dispose of the property they just purchased at some point, and then they would have the 50.
They would need to amend their cannabis permit through DCC to just have it on that one property, two parcels.
Yes, but if we allow it, it would be allowed.
If we allow, it would be allowed. If
In
but,
perpetuity.
but.
If they were to
our
withdraw the
conditions would still
application-
apply so long as the conditional use permit is in force. So even if they chose to use the two parcels, they'd still have to comply with the conditions that are going to run with the property. And that is the risk they are taking.
Yep.
So they might not be able to make use of that second parcel anyway, depending on what conditions we were to impose on them today.
well, our
Which is
conditions,
the whole reason I'm bringing it up is I just want you to see that there are both future flexibility advantages to having the second parcel and current risks.
So procedurally, they could have withdrawn the application and just gone
Right.
with the other parcel. They would still need to activate the permit for it to become effective, and they could choose not to activate it within the time frame of issuance.
go away.
And it would go away.
Right.
They could also, I believe, activate the permit and then decide we no longer want to operate under that permit. I'm not sure what the
It could
technical
essentially
term is.
expires then, though.
Yeah, it would expire, or they could say, we're no longer operating under this permit, we're just going to operate under the permitted by right rules of the DCC.
So I don't know that you could just put it on hold, though. I think it would either have to expire under the way we have things written.
No, it wouldn't be put on hold, it would be rescinded, essentially.
Yes, exactly. So we're saying the same thing, but you're using better language.
Not necessarily.
So I'm going to invite you back up.
Appreciate it.
To address comments from Commissioner Parker and Commissioner Roby, I would mention around the immediate garden area as well as the shop on site, there is a chain link fence, 6-foot chain link fence, as well as part of the settlement between the parties. We're going to be putting up a 6-foot deer fence around all of the property lines surrounding the parcel. Additionally, if you take a look at the distance between Ms. Kelly's parcel ending in 086, that L-shaped parcel, as well as the actual cannabis touching elements of that operation, which would be the garden areas and the shop, those are a significantly further distance than 75 feet away from her property lines. I would venture to say that, you know, the closest cannabis aspect of Mr. McCree's operation is probably closer to 450 or 500 feet away. All of that said, I think under the circumstances, given the comments of the commission, a short continuance, should you be inclined to grant one, may be appropriate to allow for the recording of the deeds, subject to the purchase of the parcels, further conference with planning as well as with my client as to, you know, what he would like to do with this moving forward. As well as I would inquire with Mr. Maurer, the activation period for the CUP, would that be 18 months?
That kind of approximately. We have a strange provision in our code that says it expires on December 31st of the following year. So December 31st of 2025.
Understood. And just to note, we do intend, even if the CUP were granted, to continue to operate under a ministerial permit utilizing the parcels ending in 083 and 189. Those are the furthest to the right as you're looking at them now. As you can also see, we kind of get a little closer to those parcels, and there is a pending permit alteration application right now that has us expanding into that parcel ending in 083. So we are gradually moving further and further away from Ms. Kelly's parcel and any sort of interference with that. That being said, I would be inclined to agree, it should be the will of the commission, to maybe a month and a half continuance of this matter in lieu of potential denial of the CUP. Right?
Is everybody
Well, if we kick the can down the road a couple months and everything's deeded and recorded and everything, are you going to continue with the request for CUP?
Second.
I'd have to confer with my client to give you a solid answer on that.
That's good.
Because I would imagine that if you are planning on doing that, there would be restrictions.
Understood. And I think, you know, the writing's on the wall with the comments being that likely a further setback as a condition of approval of the CUP from parcel ending in 086. And certainly I could say we're not opposed to that. Certainly the extent of that sort of restriction would have some bearing on our consideration, but we'd be happy to actually work with planning on that and potentially discuss proposing such conditions prior to the next hearing being held.
Okay. So, because like Tim said, it's not a mystery, I would propose conditions that would be primarily focused on additional clearances and fencing. So it's not like I have some strange idea out here of something I'm going to try to impose on this, but you can see what the concerns are.
Sure.
It sounds like these are things that you've already considered anyway, but, so,
To have them formalized, I think, would make everyone that much more comfortable potentially with approving it. But like when Mr. Laddish brought up, hey, you know, I'd like to see you have a survey, I was happy to say, hey, that box is checked. Fencing as well. These are all concerns that are shared not only by the commission, but also by Ms. Kelly, her counsel, and that have been addressed. But to your point, I think a little more time to solidify the staff report, amend the staff report, get the recordings in place, and have a little further discussion with planning and with my client.
Okay.
Likely would be appropriate.
So would you like it continued to a date certain? And can you guys take a look at the calendar and see what makes sense, or would you like it
July
continued?
25th or August 8th would be the
Okay.
next meetings coming up.
So the August
So
22nd meeting?
I won't be here on July 25th. I think I'm going to be the applicant in Nevada Planning Commission hearing elsewhere.
Nor will I. I'm out of town on that
The
day.
applicant was suggesting a couple of months, and
Your August 22nd meeting?
Okay. Well, yeah, a month and a half, you said, so August 8th or August 22nd would be the next available
Yeah.
commission dates.
Either of those would be fine.
Okay.
Up to you guys, whatever.
Yeah, I'll so move that we continue up until August 22nd.
Is there a second?
I second that.
Let's continue to a date certain.
Yeah.
To a
August
date
22nd.
certain, August 22nd. All in favor? Aye. Any opposed? None. Passes 5-0, and we'll see you on August 22nd. Thank you. Maddie?